Good morning to everybody who has joined already and who is joining still. As usual, I see we have a very international community here. I think I've seen almost every member state passing by in the chat already, and a lot of international guests as well, which is not surprising because we have, frankly, a very interesting webinar for you today on a hot topic as well. A hot topic that's not only relevant to our open data community, but also just more broadly for the information society and for citizens themselves. It's a topic that touches upon two subtopics actually related to data protection. Specifically, we're going to be talking today about data controllership and anonymization. Maybe a very quick introduction before we get started. First of all, good morning. My name is Hans Schro. I'll be your moderator for the session today. I am a lawyer with Timelex, a law firm established in Brussels. I'm also part of the data.europa Academy. So the group of people, as many of you will already have participated in our sessions, provides these sort of training webinars on hot topics, on current trends in European data legislation, data policy, data trends. So I have a very interesting topic for you today. This is about GDPR, about data protection. GDPR probably has the distinction of being the best known European legislative initiative in history, something that's popular enough to be known, well, popular might not be the right word, but at least well known enough to be published about in even regular everyday household publications. We have a very interesting webinar for you today. We have two great speakers. Before we get started with that, maybe even a quick recap of the rules of the game. They're the same as always, but for the new participants today, just for your information, this webinar will be recorded, will be published afterwards on YouTube as well. You will all get a copy of the slides, so you don't have to make screenshots of them. You are encouraged to ask questions at any time. You have the chat functionality available that you can use to post questions for both of our speakers. As usual, we won't be dealing with them during the presentations themselves. We have two presentations followed by a Q&A session. So feel free to post your questions. If you don't see a response immediately, it's not because we're ignoring the questions, it's because we are keeping them for the discussion session at the end. And as usual, there will also be a feedback form at the end of the session to give you the opportunity to provide us with feedback. And also, if you'd like to make suggestions on other topics for future webinars, help us make this focused a little bit more on your interests. Maybe first a couple of words before I introduce the panelists on the topic itself. So we'll be talking today about GDPR, about data protection and open data. A little bit of an antagonistic relationship. GDPR and data protection is about protecting a fundamental right and about making sure that you keep control over what happens to people's personal data, information relating to them. So it's about protecting information. Open data, on the other hand, is about making sure that data is made available as freely as possible and can be reused as freely as possible. So there's a little bit of a natural antagonism there between those two policy contexts. One says you have to protect data, the other one says make it as openly available as possible, which means that in practice, making personal data available as open data for free reuse can be very challenging in practice because data protection requires that certain agreements are put in place on what you can do with the data, with the personal data, what they call a purpose restriction. You have to make agreements on what you may and may not do with personal data. You have to be transparent towards people what you're doing with their data, which is very difficult to do if you're sharing it openly with a broad range of interested users. You have to ensure the security of the data, which again is difficult if you have a very open ecosystem. So there's traditionally a lot of reluctance to sharing personal data in open data ecosystems. We've explored already in past webinars that there's quite a bit more room for nuance nowadays. We have the Open Data Directive, the Data Governance Act, that provides sort of these more regulated frameworks for sharing open data, for sharing personal data, in circumstances that allow you to still keep control over the data and making sure that abuses can be avoided. But nonetheless, you still have quite a few situations where this causes some challenges, where open data is made available and it's not really clear whether the data itself constitutes personal data or how you can keep control of it. Maybe just a very quick example of that. This is a case that we actually encountered. It's not a theoretical example. It was about a set of open data made available in the context of the activities of an environmental research agency. It had information about bird migrations. And a rare species of bird had returned to Belgium. I'm Belgian myself. And this agency had made note of that and noted down where this bird had been spotted and where its breeding location would have been. And they made that information publicly available. That's keenly encouraged. We have legislation even saying environmental data should be made freely available, openly as possible, so that the audience knows, the public knows what's happening in their environment, that they can determine environmental impact. So they published information about bird migration patterns, nothing personal data related in principle. Nonetheless, the inhabitants of the area where those birds were spotted started to complain. Why? Because the locations of where these birds were spotted was being published. And they said, well, this is actually personal data relating to me because this indicates the house where I live. And it's not purely theoretical, but what actually happened, as you can imagine, is that very enthusiastic bird watchers started showing up in people's backyards, which is where those rare birds could be spotted, and nobody had any opportunity to see them. So these people not unreasonably complained, well, making the information about these birds available, including their exact location, is actually processing my personal data as well and making it available for reuse and also for abuse. And I'm actually seeing the impacts in practice. This is not a theoretical thing saying, I would like to, I'm a data protection fundamentalist and I want a very private life. This is actually about people in my backyard trying to make pictures of birds. So this is the kind of case where you can quickly see this data did not seem like personal data at all. It seemed like a very neutral, very easy, very open case of publishing open data, but where data protection discussions followed, where some data protection challenges were raised. So today we want to focus a little bit on some of those data protection issues, so two of them in particular, and I have two fantastic speakers with us today I'd like to introduce very briefly. We want to talk a little bit about the concept of personal data. What is personal data? What is anonymous personal data? We want to talk also about responsibility and data controllership. Who actually has to take responsibility of what data can be used for? Two hot topics, also influenced by some very recent and very interesting Court of Justice decisions that we want to present to you in order to have a sort of an open debate and show you a little bit about why data protection, also in the context of open data, is a hot topic. To very quickly introduce our two speakers. So I have with us today Ms. Karen Kuit. She's a PhD research at the Health and Aging Law Lab of the Vrije Universiteit in Brussels, where she does research on data protection, health data, and secondary use of data. She's also a member of the Committee of Medical Ethics of the University Hospital in Brussels and works on various European research projects where I think probably fair to say a large part of her job is explaining to people what actually is personal data, why this is personal data, and what that means in practice. So she's both a PhD researcher, but she's also a data protection consultant in a startup, so she also has hands-on experience on how to deal with these issues. Secondly, also we have with us Ms. Charlotte Ducoin. She worked as an in-house lawyer for the Belgian Railways, also data protection hands-on expertise, and is now a researcher on law and technology at the Center for IT and IP at the University of KU Leuven. Also finishing her doctoral research project on regulation of data. So she's a specialist on the Data Act and the Data Governance Act. Charlotte, we should have contacted you for some of our webinars on that a couple of weeks ago, but we're already very happy to have you today on the data protection session as well. As for the agenda today, so I'll be passing the floor to Ms. Karen Kuit in a moment. So we'll be talking a little bit about that line. What is personal data? What is non-personal data? How come anonymous data can suddenly become personal data? And what kind of conclusions you should draw from that? What should you pay attention to? And next to that, then we have a session on data controllership and joint controllership. Who is actually responsible? What should you do? What kind of agreements should you make? And what makes you responsible? What are the criteria that are applied there? So we'll have a very good explanation of what the criteria are in the law, but also what the Court of Justice has had to say about that recently. And there have been some very remarkable, some very interesting decisions that I think are very important for all of us to know about. And as I noted, at the end, we'll have a Q&A session. So indeed, feel free to ask your questions. We'll be parking them for the end. And with that said, I'm very happy to pass the floor to our first speaker of the day, which is Karen Kuit. Karen, the floor is yours.
Thank you very much, Hans, for this kind introduction. So, hi, good morning, everyone. I'm very happy to kick off this session. with my presentation on anonymous data, personal data, and non-personal data, and then the very fluid line between the two concepts. And I've been a bit cheeky by calling it anonymity is in the eye of the beholder, but it will become clear a little bit later why I've called it this. I'm first going to introduce myself and my research group so you know who's talking to you. Then I'm going to tell you why you should actually care about this concept, especially on this lovely rainy Friday morning. And then we're going to into two recent-ish cases that have changed the concept or ideas of the concepts a little bit. One is of the Court of Justice, and the second one is from the General Court of the European Union. And very classically, we're going to end with some conclusions. But first, a very short introduction. So as Hans already told you, I have a background as a data protection consultant. My original degree was in literature, but then I obtained a law degree after that, specializing in international and European law. And I quite recently started a PhD here at Vrije Universiteit Brussels at the Health and Aging Law Lab. The topics that I'm researching are data protection, health data, technology, and secondary use of personal data. And more specifically, I want to research if you can set up a framework for patient-empowered voluntary data sharing. So making health data more open, also using the concept of data altruism. And that's also why I'm happy to be talking to this public, because I really do believe in open data. And I think this is something that has to be possible, and open data is really for the advancement of science, and then especially in health. I think it's important. So that's my, my research area. I'm also a member of the Committee of Medical Ethics here at the University Hospital of Brussels. And I'm also active in European projects. The main project I'm working on is a Horizon project called Planet for Health, where we are looking at the impact of climate change and environment on public health. So there are a lot of real scientists who work with data, and they also gathering new data. And we, so me together with the supervisor, Professor Paul Quinn, we are the legal and ethical partner. So we advise on, what is personal data? What can you do with this? What are the ethical aspects? So we can do this scientific research, but while respecting fundamental rights. Then the group I am a member of is called the Health and Aging Law Lab. It is a very, very active research group. It's interdisciplinary. So we have some people who are engineers, but also study biomedical sciences, for example, and then studied law afterwards. And we're a member of the larger research group, Law, Science and Technology and Society. So we always take an interdisciplinary approach. And my colleagues and I are working on privacy and data protection mainly, but also advanced technologies in healthcare, pharmaceutical development and research, e-health, mHealth, and healthy aging. Those are the main research areas. And we're all involved in Horizon projects, and most of these relate to health. And then every time, we are the legal, the ethical partner in a consortium. So it's very nice to combine the academic with the hands-on experience in these projects, and feel that you're doing something for science, even though we are not actual scientists. We are, legal people. We organize a yearly symposium. It's called Health, Law and Technology. This year the topic was AI in healthcare, because this year the topic everywhere is AI. And for next year, we already have a date. So if it's something that is of interest to you, it's the last Thursday of April. And this year, for the first time, we also organized our summer school on digital health technologies. And that was a collaboration with the Technical University of Dresden, because they really specialize in medical devices. If you're interested in any of this, I have linked our website there. We also have a LinkedIn, so please feel free to follow along. But now the reason why we are here, not just plugging my research group, but the actual topic: why should we care if data is anonymous or not? Well, for the very easy reason that in the material scope article of GDPR materials, it says that this regulation, so the GDPR, it only applies to processing personal data. And if you look at definitions, personal data is any information that relates to an identified or identifiable person. That means if your data is truly anonymous and you can't find a data subject behind it, then the GDPR doesn't apply. And if the GDPR doesn't apply, I mean, I don't have to tell you, it's a lot less paperwork, it's a lot less obligations, and you also don't have to think about all the data subject rights. So it's very important to know if this regulation applies or not. And it's of course nice if it doesn't, because your data is anonymous, but you have to be very careful to make the assessment whether your data is anonymous or not. So that's a big reason to care about this. But of course, it's a little bit vague. I mean, we love our GDPR for its vagueness. Otherwise, there would be no business in it. I mean, let's be honest. So if you go to recital 26, you will find some more guidance on this. In here, you will read, first of all, explicitly that anonymous information is out of scope of the GDPR. But also you will see that if you have to determine if a natural person is identifiable from the information that you have, so from the data that you're holding, you have to take account all of the means that are reasonably likely to be used, both by the controller of the data and any other person. So that's already important to keep in mind, and it can be directly or indirectly. And you have to really look at the objective factors. So how much time would it cost? How much money would it cost to re-identify these people? And also the state of the technology and the technological advancements that are happening. So it's still a little bit fake, but it's already giving us some more guidance on this. And this is what is called the risk-based approach, the risk-based test of recital 26. There's quite a big difference with what happened before. So there are Working Party 29, Article 29 Working Party guidelines on anonymization, and they were a lot more restrictive. They don't take this risk-based approach, and they don't necessarily accept the risk that is embedded in this recital. But what is important to keep in mind is that, these guidelines, they turned 10 this year. They date back to 2014. They're from before GDPR, and so the risk-based approach is the one that needs to be used now, in my eyes. But you see that courts and authorities are also struggling with this. So if you look at the different data protection authorities and how they are interpreting this, you see that you have authorities who are a little bit more lenient. They are a little bit more willing to accept risk. So for example, the Irish CPA is an example of this, to those authorities that are a little bit more strict. And I think France is a very good example. The CNIL tends to be a little bit more strict and less prone to accept risk. Something that has been very useful for me was the halfway test, or the test of the motivated intruder, that was developed by the ICO. That's the Data Protection Authority of the UK. And I know since this whole Brexit situation, it is not the most the most relevant one anymore, but it's still a very useful test. And the motivated intruder means that there's a motivated intruder. They have their hands on a certain set of data. They are reasonably competent, so you don't have to think that this intruder is some expert in quantum computing and can do everything they want. They're a reasonably competent person. They have access to the right resources. They're motivated to know who the data subjects behind the information are, and they use some investigative techniques to find out who it is. And you use this test, in theory, on the data in front of you, and you think, okay, would this motivated intruder be able to re-identify the data subjects? If the answer is yes, then your data cannot be anonymous, then it's probably pseudonymous. If the answer is no, then you're already safer to qualify the data as anonymous. What is also important to keep in mind is that this GDPR was created, of course, to protect the very important fundamental rights of people. But on the same hand, it's also there to actually enable the use of personal data. It's not only to protect, restrict use and protect the rights, but it's also creating a framework for using data and creating opportunities to work with personal data while still respecting the rights of data subjects. And if you keep this in mind, then it makes more sense to take the risk-based approach. There's also this one discussion saying that, okay, with the technological developments that are happening, look at quantum computing, look at what we can do now compared to 10 years ago. Is true anonymization even possible? Because we don't know what the advancements will be in 5 years. It's a discussion I'm not going to go into, not because I don't think it's interesting, but to me, it's more of a paper discussion. And if I am advising people in real life, in practice, this isn't helping anyone. So that's why I'm not going to go into it, but know that it exists. And it is very interesting, but it's not a very pragmatic discussion. So now I'm going to discuss some of the recent case law. So the first case I'm going to talk about is also nicknamed the Scania case about the relativity of the notion of personal data from November last year. And it's about the classification of vehicle identification numbers, or VINs. The second case I'm going to talk about is from the General Court. What is important to bear in mind here is that this case is not actually about the GDPR. It's about the other regulation, like the GDPR for European institutions. But because the definitions are the same and the concepts are the same, it's still relevant to look at this and then transpose this to the interpretation of GDPR. So that's why they are mentioned and they are relevant. The case that I'm going to talk about is the Single Resolution Board against the European Data Protection Supervisor. The appeal is pending, so it's not something that's completely clear yet, but it's about opinions of shareholders and creditors that were shared by the SRB to third parties. There's also a second case mentioned there, but I'm not going to go into it because we only have 30 minutes and the case was a little bit absurd. But if you're interested in it, I did write a blog post on it that you can find on the website of my research group. But we're not going to go into it today. It was also appealed. But the fundamental question in all of these cases is what makes information personal data? And that's also the question we're talking about today. So the first case, first the facts. The official name is Gesamtverband Autoteilehandel, but you'll probably find it under Scania. So there's this European regulation that says that vehicle manufacturers, and then Scania is one of those vehicle manufacturers, and authorized dealers need to provide certain information. They need to make available certain information to repairers of vehicles and independent operators. And Gesamtverband Autoteilehandel is, they represent certain independent operators. And the way that Scania, so the vehicle manufacturer, provides this information is they have a website, and on this website you can do a search either based on the last 7 numbers of the vehicle identification number or the VIN, or some general vehicle information. And Scania never provides this number, never provides this VIN to the independent operators, but that means that only repairers have access to this, because I don't know yet if you have a car. I live in Brussels, I don't have a car, but I know where to find the VIN. There's a sticker somewhere in your car, and on that you will find this number, you will find this VIN. So if you are a car repairer, you have the car in the shop, you have physical access to it, you can just go look at that sticker, you have the VIN, you have those last 7 numbers, you go to the Scania website, you find all the information that you need. But then, of course, you need to have the car there physically because Scania is not providing these numbers. And what Gesamtverband was saying is, Scania doesn't provide sufficient information. We have the right to this information under this regulation, and we don't get it through this way. So that went to court, to German courts, that then went to the Court of Justice of the European Union. And then the German court also asked, okay, but if indeed Scania has to provide this VIN, does this mean that even though in their eyes the VIN in itself is not personal data, does it mean that this regulation also creates a legal obligation to process personal data? Which is important because if it does, and you process this personal data, you can do so on the legal basis of Article 6.1c, because you always need a legal basis to process personal data. But one of these legal bases is that you have a legal obligation. So if this regulation does create this legal obligation, you can process this data. And then this is what the Advocate General and the court found. So they first referred to an older case of 2022, that I'm not going to pronounce because I think it's Finnish. But in there it was already stated that VINs are personal data, but here the Advocate General says, look, I don't agree because a vehicle is not always owned by a natural person, and that's true. For example, think of a truck. It's not the truck driver who is the owner of the truck usually. It's usually a company that is the owner. So again, personal data is only natural persons, not legal entities. So if the owner is not a natural person, the VIN cannot be personal data. But the AG then concludes, okay, VIN can be personal data, but only if the entity holding the data has some access to means to reasonably allow them to identify this owner of the vehicle, and this owner of the vehicle is a natural person. Now, what is important to know is that there's a directive that exists that says that cars need to have a registration certificate. And on the certificates, you will find the VIN, but also the name and the address of the owner of the user. Meaning, if you have access to this registration certificates and you then get a VIN, you can connect the dots, and this VIN, you can find out this car in my shop actually belongs to Hans. So then it can be personal data. And then then if that's actually a natural person, the VIN is personal data. So what they then say is that an independent operator, they quite reasonably have at their disposal a means to get access to this registration certificate, so they can re-identify a person from this little number, from this VIN. That means that the regulation here does create a legal obligation to process personal data if VINs need to be transmitted, and VINs can be personal data. In a little schedule, so if an independent operator has means to reasonably identify the owner or the legal user of the vehicle, for example, through those registration certificates, then the transmission of that VIN, so that number is an example of a VIN, that transmission of data is a personal data transfer, and it can be done on the legal basis of Article 61C of the GDPR. If this operator has no means to identify this person, so they only have that number, they don't have access to some database where they can link that number to a natural person, then that means that this transmission of data is an anonymous data transfer and GDPR does not apply. And then, they conclude by saying it's up to the referring courts to decide which scenario applies because it can change from country to country what information operators have access to. So some key takeaways. This is confirming the tests from recital 26 to determine the nature of data. You look at the objective factors, you look at the means they have at their disposal to re-identify people, and from really looking at the situation at hand, you decide whether the data is personal or not personal. And also what they're saying here is that the personal nature of data can be relative, because for a manufacturer who only has that VIN, I mean, they're just creating cars and numbering them. This is anonymous data because it's meaningless to them. But if that number is then transmitted to someone who has access to registration certificates or some other way of re-identifying, this little piece of information becomes personal data. So, going to let that sink in for a second and have a sip of water. The second case. So the second case is the Single Resolution Board against the European Data Protection Supervisor. Not survivor, supervisor. And it's not about GDPR. As I said, it's about Regulation 2018/1725. But since the concepts are the same, the definitions are the same, this is something that we can look at to interpret the GDPR. What happened here is that there was a Spanish bank, Banco Popular Español, that was placed under resolution according to a procedure that is also found in a European regulation, and the SRB, or the Single Resolution Board, which is a European entity, I don't know how to say it, they had to perform a valuation to check if creditors and shareholders would have had received better treatment, which is the normal insolvency procedures, instead of being placed under resolution. So it's to see if the rights were respected, if this was the best way for the people who were actually affected by the fact that this bank was placed under resolution. They did this valuation, and then they sent it to a third party for assessment, for an independent assessment, in this case, Deloitte. And how this valuation happened, one part of it was well, respecting the right to be heard for affected creditors and shareholders. But first, to enable to know who actually had this right to be heard, who had the right to express their opinions, express their comments, have access to this information, they first had a registration phase where everyone who deemed to have been affected, they had to provide some documentation to prove who they were, and to prove that, yes, I am a creditor or a shareholder, I am affected, I have the right to be heard. And then after this phase, these data were then pseudonymized with an alphanumeric code. And then after this, everyone who had been deemed to have been affected was invited to provide their comments on the valuation through an online form. In both of these phases, the data were processed by employees of the Single Resolution Board based on this alphanumeric code. So there's definitely a key to re-identify everyone. But for each phase, there were different employees who were processing. So the employees of the second phase didn't have access to the key that was created in the first phase. And then after the comments had been processed, also some comments were aggregated, for example, when a lot of people were saying the same thing. The valuation was then passed on to Deloitte, so they could take that into account for their third-party assessment. Some of the creditors and shareholders got wind of this, and they complained, saying like, hey, you're passing on our personal data, and we never got information on this data transfer. And under GDPR, you have to be transparent. We have a right to know what's happening to our personal data. And the EDPS said, yes, indeed, you should have been informed. They reprimanded the SRB. But the SRB, they didn't agree. They say, no, these comments, they're not personal data. And Deloitte, they never had the key. They never had the means to reasonably identify the people behind the comments. So in their eyes, this was anonymous data that they passed on, meaning that they didn't have to be transparent about it to the data subjects. So these are the findings of the court. First of all, it's important to note there had been an older case, it's called the Nowak case, that already determined that opinions and comments can be personal data. They're not necessarily personal data, but they can be personal data. But what the court immediately says is the EDPS and their reprimand, they hadn't actually examined the content of these comments. They hadn't done the examination, are these comments personal data or not? And then secondly, they also stated that it was impossible for Deloitte to re-identify the data subjects behind the comments, because there's this prior case, it's a bit older, it was about IP addresses, and it was already determined that not information needs to be in the hands of one person to re-identify. So it's perfectly possible that there's a key and there's a different set of data, and it's not because they're not in the same hand that it's automatically anonymous. But in this case, you have to look at the possibility to re-identify from the point of view from the entity who's holding the data. So in this case, they had to look at it from the point of view of Deloitte. And for them to obtain that information, to obtain the key, to change the alphanumeric code or change the comments back to the people behind them, they really would have had to hack the servers of the SRB or break in and find some paper record that hopefully doesn't exist. So really, it would have been illegal and highly impractical for them to do this. Just from the comments itself, they couldn't do it. So that's why the General Court decided to annul the EDPS's decision, stating that since they didn't investigate whether Deloitte had any legal means available to it, so they could actually access this information in practice. So not just the theoretical, but you have to look at, is this really possible in practice? They couldn't conclude that there was actually a personal data transfer, so they shouldn't have reprimanded the SRB. So we see some conflicting views here. We see EDPS saying like, no, the key exists, data is pseudonymous for one, so it's pseudonymous for all, where the general court is saying like, no, this data was pseudonymous for the SRB, but that doesn't necessarily mean that it cannot be anonymous for Deloitte. Some key takeaways here. One very interesting one, I think, is if you're looking at the objective factors of can we re-identify, you don't have to take into account someone hacking into the service of the SRB, apparently, so you don't have to look at the illegal means and the bad actors. Again, the relative notion, it can be pseudonymous from one perspective, anonymous from another perspective, but please do keep in mind this decision was annulled not because the comments were not necessarily personal data, but because the EDPS didn't actually investigate this possibility of re-identification. And it's definitely to be continued because it's appealed. The appeal is pending, where the first ground is the incorrect interpretation of some of the concepts. And I've seen that by now the European Data Protection Board is also intervening in the appeal case to support the EDPS. So it's definitely something to watch. So I'm already going to some of my conclusions. What I see from these cases is that the General Court and the Court of Justice of the European Union seem to be taking a more pragmatic approach, and it's also the approach that we take in our practice. We always look at the case at hand. We always go over the real risk, and it's something that the courts are doing too. So it's something that I can only cheer on, I think. But I think the biggest conclusion here is that it is unclear. It is unclear for people working with data. It's unclear for data protection authorities. And we'd love some guidelines. The guidelines were planned by the EDPB in their previous working program, 21-22, and now again in the work program for these 2 years, 23-24. So it seems that it's something that is being worked on, and it's for sure something that will be welcomed, but it's such complex material. So yeah, I'm kind of happy that I'm not the one working on these guidelines, but I am looking forward to reading them. And then you see that the Court of Justice seems to embrace zero risk is impossible, anonymization can be reversible, while on the other hand, EDPS and maybe EDPB too, since they're now intervening in this case, they seem to be taking a more absolute stance, although to be fair to them, they did also publish this document, Misconceptions on Anonymization, coming from the Spanish Data Protection Authority, where they also say like, okay, anonymization, there's not always a zero risk. So it's not, I'm not saying that they're completely absolute and know everything, but they're less risk prone than the courts, or that's how I interpret these cases. So thank you very much for bearing with me until the end. I'm looking forward to some questions at the end. And if you do want to connect with me, feel free. My email is on there. My LinkedIn is on there. I'm always happy to chat about the subject. Thank you very much.
Thank you as well, Karen. It's a very interesting session. It's some very interesting topics indeed. And at least from my side, even I've learned a couple of new things already on the motivated intruder test, which I think is indeed a very good criterion, which I've never at least heard it called under that name, but it's very sort of intuitive and very recognizable to say, well, could a motivated intruder identify somebody on the basis of this personal data? So that to me is an interesting one. And indeed, I do think we also need some guidance on this. Also on this issue of the perspective, the point of view test, which we had in the SRB case, because that creates a whole bunch of new difficulties. If they say, well, it doesn't just depend on the context, but you have to consider the point of view of the data holder, which is, data holder is not a concept that traditionally we worried about in GDPR. I think this is something that's filtering in from other data legislation. So I think, that's we could welcome some new guidelines. We have some super interesting questions also that popped up already. Feel free to have a look at the chat. We will come back to them in the Q&A afterwards. I think some very interesting points were raised there as well. Before we do, though, however, I do want to pass the floor to our second speaker, Charlotte Duquin, on data controllership and responsibilities, and actually basically has to make sure that GDPR is complied with And unfortunately, for those of you who thought this was complicated already, this probably will not simplify matters too much, but it's a very important perspective to take. Also, because we've actually already had questions in the chat saying, what is our responsibility actually? What will we have to do? So yeah, Charlotte, I will happily pass the floor to you.
Thank you very much. There seems to be some echo. Can you hear me well?
Yeah, it works from our side. It's okay.
Okay, so I just have to bear with my own voice. Okay,
and interesting to note, the captioning does seem to work now directly for you. So for the first audience members who asked for it, they will be able to watch the captioned version on YouTube after it's published. For you, apparently, we can follow it live. I'm curious to see how well it goes.
Okay, great. It's just that I can hear my voice as an echo, and I'm not used to that, so it's a bit uncomfortable, but I'll find my way. Well, I wanted first to thank you, Hans, and Europa Academy for having me here. So just a few words of introduction as to why I'm interested in data controllership. So I'm finalizing, actually my PhD is finalized. I looked into what I call the compatibility model of the EU between data market and data protection with their new data legislation. So mainly Data Act and Data Governance Act. And from that perspective, I looked into data controllership with respect to two different aspects. So the first one is how data protection relates to data codification. And the second aspect is whether with this new data legislation, there's an enhanced risk that data subjects become data controllers concerning the processing of data relating to themselves. These are questions that I will not really discuss here. I will look into controllership in a more general manner. But of course, we can also reconnect later on with anyone interested in these topics. So just an overview of data controllership in the GDPR. So why do we have controllership? We have controllership in order to allocate responsibility. That's the only thing that the law does, allocating responsibility. So we had the presentation of Karen on what is it that we talk about with the GDPR, the scope rationnel matériel. Now, this is the scope rationnel personnel. So who's in charge? And I would say these are the two most difficult parts with data protection. So the main figure we have here is the data controller. The data controller is the one that alone or jointly is responsible for compliance with data protection obligations. I explain why and on which basis. We have the data subject, who are both the beneficiaries and the protected individuals. So the notion of data subject connects to the notion of personal data. So data subjects are the natural persons who can be identified through data. This was discussed by Karen. We have the processor or data processor. The processor is an entity that processes data on behalf and following the instructions of data controllers. So data processors are not the main entities having responsibility, but still they have specific obligations. Also, you have to know that they might become responsible, meaning controllers, upon acting beyond the instructions of data controllers. And finally, we have the notion of data recipient, which can be connected to this of third parties. So data recipient so the data recipient is any entity that receives personal data, for instance, from the controller. So you can picture, for instance, a chain of independent controllers who transfer personal data from one to the other. So now the notion of controller is a central one when it comes to allocating responsibility. So the definition we have in the GDPR of a controller is that the controller can be anyone, basically, so a natural or legal person, a public authority, etc., that alone or jointly with others determines the purposes and means of the processing of personal data. So, as I said, it can be anyone, even a natural person. It can be either one or several controllers, meaning that you open the door to different types of responsibility allocations there. So newly with the GDPR, we have the legal recognition of joint controllership um, with dedicated obligations in Article 26. I will touch upon them, but not too much. But in the case of joint controllership, let's say here is that those joint controllers, they shall allocate between themselves the responsibilities for compliance. Importantly, controllership is determined based on a functional and mainly factual approach. That means that in practice, you need to look into who is determining the purposes and means of the data processing. So there's an exception, which I think is relevant in the case of open data and more in general in the case of the public sector. The exception is where the controller is identified by law. And we have very recent case law that says that this identification can be either explicit or implicit. So these are, let's say, basic notions of what is a controller, what is controllership. Now, of course, we know that the law books is not the same as the law industry, as we often say, meaning that when you turn to practice, it's sometimes complicated. One question that data protection had to deal with was cloud computing at the time. So what happens when the alleged processor, such as cloud computing service provider, either makes significant decisions on data processing or has the power to do that? So we have, as you know, huge cloud computing service providers who are able to impose boilerplate terms and conditions to different types of industries, public sector bodies, and so on and so forth that have a huge impact on how data processing takes place, and sometimes even why. So then what happens? So that was one of the questions that data protection had to deal with. Okay, so another very big question that we have with controllership is where does responsibility of one start and end when data processing is highly fragmented and interconnected? So we have it in different contexts. We have it in the context of simply whatever happens online. We have the blockchain, let's say, quite specific case. Also, maybe something you are interested in is the new Data Governance Act, and especially Chapter 2, that provides for the means for public sector bodies to make available data that are protected by rights of third parties, including because of data protection, to other parties. And then the Data Governance Act lays down certain legal and technical rules, measures that public sector bodies should put in place or have in place through other public sector bodies to do that. And then, of course, it raises the question of the responsibility of all those actors down the line. Finally, we've had the question in different shapes of what happens when data subjects tend to make decisions on data processing so that they might actually become controllers. So we've had this question in the past with respect to data subject activities on online platforms such as Facebook. And now we have this question that I've looked into my PhD of how the Data Governance Act, and to a certain extent the Data Act, might actually turn data subjects into controllers of their own data because of the ways in which the EU aims for them to have more control. Okay, that was a teaser, but I'm not looking into all these questions. I would like to emphasize a major shift that has taken place in the case law recently. So I will actually contrast what I call the traditional view with the newer view, and then see where we stand now. So the traditional view is one that connects controllership to purpose, to make it maybe a bit simplistic. So the notion of purpose is very key to data protection law. A purpose is the anticipated outcome that is intended or that guides one's planned action. So Working Party 29, the predecessor of the EDPB, says that purpose is essentially what answers the question to what end or what for data processing takes place. The notion of purpose plays a very significant role throughout the GDPR. And with respect to controllership, it's important to bear in mind that the purpose serves to identify and delineate the relevant data processing obligations under the responsibility of controllers. So that means that the compliance analysis of the GDPR starts with the purpose for personal data processing to allocate responsibility and then to tailor obligations. So this traditional view has been applied in the Google Spain case that is very well known. So in the Google case, we had the question under the GDPR, under the Data Protection Directive, we had a question whether Google, when it comes to the Google search engine, processing of personal data should be considered as a controller. Of course, Google said no, and everyone said yes. And the court eventually said yes. So no suspense here. The main argument was that compared to website publishers from which Google gets data, including personal data, so Google was saying, well, I just reuse data, that are out there. So it's just that. It's not much that I'm doing. But the court said, no, it's different. Why is that so? Because Google has a different and an own purpose for purposing such data compared to this of website publishers. And as a result, there is additional interference with fundamental rights of individuals. So this case law was then applied very recently in a case that I will there spell out. So this traditional view has been weakened and then actually reversed in other cases. So we have the Wirtschafts Academy case in which the court had to decide whether an entity, Wirtschafts Academy, that manages a Facebook fan page, whether that entity should be considered a controller. Then we had the Jehovah case that deals with Jehovah Witnesses community case, in which the question was whether the community itself should be considered as a controller for the processing of data that takes place through door-to-door preaching by its members. The third and most important case here is the Fashion ID case, another case that involved Facebook. And then the question was whether a website publisher that embeds within its website a social plugin, such as like the Facebook like button, whether that in itself is sufficient for you to qualify as a controller. There are commonalities between those cases. So an extensive interpretation of joint controllership in this case, with the idea that this law alone is necessary to ensure high, effective, and complete protection of fundamental rights. The court, in all those cases, found that there is joint controllership. And a very important element is that in case of joint controllership, the court steadily found that every and each controller does not necessarily have to have access to personal data. And also something we'll deal with now is that joint control and joint controllership does not necessarily mean joint responsibility. Very unclear what it means. A lot of people have tried to explain that, and the court is actually still struggling with its own case. So this crystallized into the Fashion ID case. With this case, the court endorsed what you could call the data processing operations-based approach to controllership. Some have called it step-based approach. What the court has done is to try and disentangle the different data processing activities that are being conducted. So first, data collection, then data transmission, and then data analytics. In this case, you had Fashion ID, so this website publisher, that through the embedment of the Facebook like button, by doing this, that allows Facebook to access personal data that are collected through this website and that are transmitted to Facebook. And then Facebook conducts further data analytics. So what the court says is, well, in the data collection and data transmission cases, you have joint controllership of both Fashion ID and Facebook. And then data analytics is only conducted by Facebook, so Fashion ID is not responsible for that. So that means the court tried to identify the actors who exercise influence, both purposes and means, for every relevant data processing operation. So what is the consequence of this is that where in the scope where there is no controllership, the court considers that the controllers have to arrange between themselves responsibility. In this case, Fashion IT had to essentially deal with transparency obligations and um, the obtainment of consent from individuals. So I explain why it's a problematic case. But before that, I would like to ask the question, well, was it just a mistake? Because it's a problematic case, but is it just, one mistake that has been corrected then? Actually, unfortunately not. We've had the same approach, step-based or data processing operation-based approach that has been later upheld by the court, both in the context of controllership determination and also outside of the context of controllership determination. I'm not going into all the details of the cases. They're also quite unclear in my view from that perspective, but my finding there is that it goes along a certain demis of purpose and of the role that purpose plays or actually should play in the determination of controllership. Importantly, the EDPB, so the European Data Protection Board, has issued an opinion after the three cases, Verchers Academy, Hova, and Fashion ID, to try and give a working synthesis of the criteria that would be identified based on the case law. Because there was so much unclarity that the EDPB tried to make sense of them. And to a certain extent have been then followed by the court. So according to the EDPB, there are 4 different criteria. First, when it comes to joint controllership, you have to have joint participation. Second, in the determination. Third, of the purposes and of the means. So joint participation implies either a common decision of those actors that are potentially controllers, or converging decision, which is the new notion. So converging decisions are decisions that complement each other and that are necessary for the processing to take place as it does. Of course, the EDPB had to agree because the court was so explicit on the fact that access to personal data by every such actor is irrelevant, although it raises questions. The second important element is the determination of purposes means. So determination implies a certain influence over processing. One of the questions that is raised by the new approach of the court was this of the scope of the data processing operations that you should look at. So in the eyes of the EDPB, you have either a micro level or a macro level. A micro level would be this that the court applied in Fashion ID, where you have data collection, then data transmission, then data analytics. So for all those little operations, then you have to identify controllership. The EDPB is to loosen the case law of the court by saying, well, you don't have to have this micro view. You can also have a more macro one, let's say the purpose one that we had before, but it depends on the context. Good luck. Then the purposes. So in case of joint controllership, it means that you should have jointly determined purposes, either common purposes or different purposes that are closely connected enough or complementary enough. Still, the EDP says that each actor, and I think it's very important, each actor should have a purpose for data processing, because otherwise you open the door for any sort of you just have joint controllership of everyone for everything. Fourth, in order to have joint controllership, you have to have jointly defined means, which does not usually mean that everyone has the same role in determining means. So where do we stand now? The case law is complicated. The case law is not necessarily consistent. You don't have one methodology that is applied throughout. And DDPB, I think, has provided useful expertise, but not enough so you have a very clear view on how to go about it. So a few elements. The joint participation as either common or converging decisions. This that the EDPB stated has been partly endorsed by the court then in the recent IAB Europe case, but in a slightly loose manner. So the court considers that you don't have this necessary condition, but only tangible condition that impacts on the determination of the purposes and means. Second, as I mentioned before, this, I think, problematic micro-level view of the identification of data processing operations relevant for the determination of controllership, the EDPB kind of weaken, loosen the case. And I think the aim there is to restore the notion of purpose as the one concept that ties together data processing operations. So I get the point that I think the EDPB is right in doing so. The problem is we don't have really guidance on when, in which circumstances you should go for either the micro or the macro approach. Also, I'm not sure it's actually in line with the case law, although I'm not sure the case law is right in doing this at all. So this is a complicated and I think problematic one. Then the EDPB clarified something that had been very unclear before, that what is joint is not the joint purpose, but the joint determination of the purpose. And I think it's a very good step in preserving the function of purpose by avoiding overly extensive purposes. So we had questions, interpretative questions on whether Fashion ID and Facebook were tied in as joint controllers just because they both have an economic interest in the processing of personal data, which I think would be just opening a Pandora box of purpose having no legal meaning whatsoever. Yet I'm not sure it's completely in line with the case law, although a problematic one. Then, okay, that probably I won't deal with that because it's a bit technical, but maybe we can deal with it in the Q&A. But the court said essentially that every and each of the joint controllers should first be identified as a controller independently of the other potential controllers, and only then should you look into what is joint. The problem is that the joint determination of purposes kind of stands in the way of the approach. I think a good thing that the EDPB has been doing is to distinguish between the determination of the purposes on the one hand and this of the means on the other hand. And I think it's doing a good job in trying to limit the overextension of joint controllership scenarios that were feared after the case of the court. The fact that each controller should have a purpose, so that's what the EDPB says, again, it's doing a good job in trying to prevent an overextension of joint controllership scenarios. And it bans what has been called indirect benefit-based approach. So indirect benefits-based approach is the approach whereby anyone who would benefit from data processing in some way could end up being actually a controller. And I think you have to have a purpose for data processing that gets you closer to the actual data processing activities that are taking place. A problematic finding of the EDPB, but they had to keep it because just the court had it, was that every and each joint controller does not necessarily have to have personal data in order to be identified as joint controller. I get the point of the court. They wanted to prevent undue circumvention of data protection or evasion of the law even, but there is a risk of over-inclusiveness of joint controllership. And yeah, we can go into details further, but I think you lose the connection to actual data processing when you do that, which raises problems that we've also seen in a few cases. So I'm finishing with this slide, Hans. I know it's about time, but with all the interruptions, it's a bit hard to keep track. So where do we stand now? There's a lot that can be said. It's not easy to deal with controllership at all. The picture we have now is a complicated one. Same as Karen said with the identification of personal data, I'm happy I'm not the one making decisions because it's not easy. What I think could be a way forward is to see that actually some of the questions that we have tried to answer with controllership might actually not be controllership questions. Christian van der Horst, she's data protection and other fields. She's a scholar in many interesting fields. She suggested some years ago that we lack rules on controller to controller data transfer. For instance, should you have due diligence obligation upon data transfer? And I think this is something that we miss. And because we miss that, we try to kind of force these due diligence obligations in the notion of controllership, ending in this kind of overly inclusive controllership notion. In the specific case of public sector, which might be of interest for the audience today, so the GDPR says that states may nominate public sector controllers. But I'm wondering whether, so we've had cases in which it's been problematic, and I'm wondering whether there actually should be an obligation for states to do it, and also to grant such actors the actual competence to act as a controller, because public sector bodies, they are tied to the public sector obligations, to the law that determine their competencies. So when they happen to be de facto controllers, but they don't actually have the means to act as one, then that's a problem. And third, but it's also a huge question, I think several of the cases, they actually go to the relationship between data protection and other fields of law, such as corporate law and the law association. Yehovah, for instance, IAP Europe, probably. And I'm thinking that maybe we should do more to understand the relationship between the two. So I'm sorry, Hans, I was a bit over time, but that's the end of it.
No worries. Thank you very much. It was an interesting, very interesting presentation. Sorry for the audience also for the audio difficulties, and also to you, Charlotte. I know it's a little bit annoying to have to worry about those things. Hopefully, we'll have less of a problem in sort of the Q&A sessions. We did get a lot of interesting questions from the audience, so hopefully we'll be able to pick up on a bunch of those. I just want to point out before we start, there is actually an interesting a common element, something that you both said. I don't know if you did this intentionally or if you noticed it yourselves, but you both said, I'm glad that I'm not the one who has to decide these things. So that's not a great sign on legal topics, where basically the experts have to say, oh, this is tricky. I'm glad that I don't have to make the decisions here. Let's dig into a couple of the issues, some of the questions that have been asked in the chat. I'll start with Karen on the basically on the concept of personal data and some of the questions that have been asked there. A lot of the questions there, a bunch of the questions are sort of about the relativity and the context of personal data assessments. One of the questions seems a little bit theoretical, but it actually isn't. It's just the question of, is the concept of definition of the concept of personal data, is that becoming more relative over time, that requires more and more consideration of the context and what an individual person would do. And now then, apparently, at least under the Deloitte case, what a data holder might be capable of doing. It seems like, we used to have tried to do this more objectively, and maybe that was naive to begin with, and to say, look at the data sets and look at the possibility of linking it. And it seems now to require more sort of a permanent evaluation and a permanent reassessment. How would you sort of look at that question, the relativity of personal data?
Okay, thank you for the question, and also thank you, Charlotte, for your presentation. I did learn some things, so thank you. So I wouldn't actually say that it's becoming more relative, but what we are seeing right now is when the GDPR came out, it's now maturing a little bit, and a lot of what was in the regulation was unclear, was a little bit in the gray zones before, and just some of the concepts are getting clarified because there are contentious cases, it's going to courts, we have the data protection authorities who are very active, and some things that were just a little bit more vague in a regulation, a little bit vague when you just have the piece of paper in front of you, are getting clarified. And I think it was always like that risk-based approach, and that really looking at the situation at hand, looking at all the factors, that was always meant by GDPR, the way that I read it. But yeah, for example, from the second case I discussed, from the Deloitte case, I had one client, I told her about it, and she was like super happy. So many of those things are now anonymous.
We've had that as well. Like,
Yeah,
now I'm
so
off the hook. That's not my problem anymore.
Ecstatic pharmaceutical client who was like, we're off the hook. But yeah, it's definitely not that that's not the case. It's still quite restrictive. It's not a blank slate to just say like, we don't have the key, so it's anonymous to us.
Because that's indeed weird, because it's like it's the one that's doing the survey, the SRB in this case. For them, it's clearly personal data because they have the key, no question, and then they hand it over to a service provider, and for them, and somewhere in the course of that transfer, it no longer is personal data, which is also that weird and practical implication. Do you need a data processing agreement to begin with? If you're a service provider, for them it's not personal data, but for you it is. So it's a very weird, and this is indeed what's I've encountered as well, companies saying, oh, so if I just pseudonymize responsibly and I put in appropriate shields so that my service provider can never link the data back, then I'm off the hook. Then there's no more GDPR for me.
Yeah, but that's not really what the case is saying. In this case, it was just so impossible to get that key. But very often you can get the re-identification through other means, like there could be a data breach where there's a lot of information available. It can just be already publicly available. So there are many, many ways to re-identify. But in this case, there were aggregated comments that you really had to link back. You really, really needed that key, and like the two bases of keys. First, you needed to get back to the surveys with the codes, and then from the codes to the names. So it's definitely not as relative as some clients had hoped.
Some would like it, and also you're right. It's a very specific context, also because Deloitte has no reasonable way to force the SRB to hand over the key and to relink the data, and that's a very rare circumstance as well.
Yeah,
basically.
And no motivation either.
Indeed. I have actually a bridging question for you, Charlotte, because there's one, I think it was posted during Karen's session, but it actually relates to data controllership as well. There was a basic, very straightforward question. If a person provides personal data and specific comments, for instance, in the context of an anonymous survey, does the institution have responsibility under GDPR here? Which I read the question as, are you a data controller? So I'm thinking of the issue where you're collecting data as anonymously as you can, maybe even fully anonymous, telling people, don't give me identifying information. What if they do anyway? Like if they give you personal data despite the fact that you did not ask for it, and in fact maybe even explicitly told them, don't tell me that, which is also kind of related to the SRB case, because there also the feedback was supposedly anonymized to the point that you couldn't link it back anymore. Does that, how would you think then? Can you be an accidental data controller without wanting to be, or how would that be approached? It's different from the cases that you discussed, but I'm just interested in your opinion on that as well.
Thank you. Okay, I can see now that the other problem are connected to the transcription. So I can't fix it. I'm sorry. I don't know why it's so bad with me. It's the first time it happens to me. My opinion would be, so as you probably understood, I rather stand with the purpose approach. So I think if you don't have a purpose for the processing of personal data and you do stick to that, I don't think you should be a controller. So you just delete what is personal, actually delete it, you don't process it, you don't have a purpose for it, so I don't think you should be a controller. Then in this case, I would say it's the person that introduced themselves some personal data that do seem to have some purpose. So of course, it's hard to say in the abstract, but that would be my intuitive approach to it.
Yeah. So you do have to be diligent. Like if somebody hands over personal data that you did not ask for, you can't say, okay, well, I'm deleting this right now because I don't want it. And then you can say, I had no purpose. In fact, my purpose was not to have personal data, so I'm just getting rid of it. Maybe I'm a data controller for the act of cleaning up my data, but that's the end of my responsibility because I did not choose to be a data controller here. I did not choose it, and it was just sort of imposed on you.
Yeah, I think what the EDPB reiterated that in order to be a controller, you have to have a purpose. And in my view, a purpose that is tied to data processing. So with a sense of direct interest detract from data processing. Without that, you should not be a controller.
Yeah, indeed. I think that's probably, there's sort of a common sense approach here, because there's a follow-up question in the chat, but I think it kind of boils down to the same thing. Like, if you're an accidental data controller, like, do you have to have a privacy notice? And I mean, technically, maybe yes, you could say, well, even if I have to get rid of that, that's an act of data processing. This is like, it seems like over-engineering the problem a little bit. This is, I don't think a data protection authority is going to say, oh, you accidentally process personal data, so now you need to have a privacy policy and identify your legal basis for deleting it. That's probably a little bit over-engineering. People are really digging their teeth into this problem, but I want to skip to in the chat. I want to skip to something else that I'm pretty sure, Karen, I don't know this for a fact, but I'm pretty sure you're working on this as well. Somebody asked the question about using synthetic data as a privacy-enhancing feature. Since you work on healthcare and data protection, probably you've seen these issues before, but for people in the audience who are less familiar with it, synthetic data, I'm oversimplifying probably a little bit, basically means that an algorithm, nowadays often an AI algorithm, basically generates fake data that is realistic. So essentially, you train your artificial intelligence on the real data to say, for instance, in healthcare, these are realistic values that you might get for blood values, heart rates, whatever, realistic values. And on the basis of that, it generates fake data that look like the data of real patients, but that actually isn't the data of real patients. So you still have data processing in the analysis of the original data, and then in order to generate the fake synthetic data. But the whole promise basically is you could get a good enough outcome because the result is that the data should be as realistic and as useful as actual data. But it isn't personal data because it doesn't relate to real persons. It's generated and fictitious. Have you encountered that already in your research?
I know what it is, and I know it's one of the things that EDPS is also working on, because they have these tech dispatch reports where they track technological advancements that are interesting for privacy. So cryptocurrency was one of them, but synthetic data is also one of them, I think. And if that's truly the case, if it's truly anonymous data that is still useful, then sure, why not? But I'm a little bit skeptic about it, because I know last year there was this big paper about, it was image creation through stable diffusion. And there was this paper saying like, hey, even though these images are created through stable diffusion, they're not actually, they don't copyrighted or anything. They showed that a reasonably competent person could actually quite easily get to the training data. So then that is not okay. So if that means that the synthetic data can also be reverse engineered and you can get to the training data, which will be personal data, it will need to be trained on real data sets, then I'm a little bit skeptical about it, because I see more and more that people are able to reverse engineer these types of data.
Mm-hmm. It's an interesting concept, but a lot of it sort of hinges on the quality of the process. It's only useful and only meaningful if you need your synthetic data is realistic to begin with. It has to be real enough, and it's never going to be as good as the original data, but it can be viable to work on this process. But then indeed, like you said, also you have to make sure that no actual personal data filters through somehow, because then indeed the benefit disappears. But still, it's an interesting hypothesis. There seems to be a lot of experimentation with that field. That's it's a very interesting one. There is actually was also a question. I think this is more for Charlotte, that I found interesting about using cloud technologies. It mentions big five, so that the big cloud providers, in this case in the context of education, school administrations. And this is actually, you talked about this, about cloud computing being one of the difficult cases of deciding who is actually the data controller. Because sort of traditional perspective is, cloud providers, they're service providers, and so they're the data processors acting on behalf of, in this example, the schools. School has a data processing agreement with Microsoft, Google, Amazon. Doesn't actually matter that much who it is. So controller is the school. But the question that the member in the audience asked is, well, is that realistic? Because in practice, those big organizations will almost invariably use that data to some extent for their own purposes. And also, how realistic is the test? And this is a well-known issue. If you're working with, I don't know, any one of the big five, any of the cloud providers, even if you put on paper you are the data controller, you determine the purpose and means, certainly as a smaller user, and on the scale almost everybody's a smaller user, you actually have zero influence on the means, at least on the technologies used. On the purposes, yes, I guess you were able to decide what you want to use, what kind of services you want to buy, but it becomes very very relative. So just curious on whether, what your perspective on that is, whether the controllership and processorship paradigm or approach, whether that works, and whether indeed it would be appropriate to say, that cloud provider is your processor, or whether you should go more to a joint controllership type model, and what the influences of terms of service. Sorry, those were a lot of questions stacked together, but it's part of the same package.
Thank you. I agree. It's a great question. I don't want to commit too much on that because there's a lot that's been written, including by the EDPB, very interesting opinions, and also by national courts, a bit less by the European Court. What I can say here is that the GDPR was tasked with the mission to try and solve that. And I think the whole regulation of data processor and the relationship between a controller and a processor is really meant to tackle those problems. So before the GDPR, that is not that old actually, you had the Data Protection Directive, and we already had those issues with cloud computing. So now with the GDPR, you have a lot of regulation of what the processor can do and shall do. One of the ideas is that the data processor may become a controller upon having their own purpose for processing personal data. That's an important one. Another aspect is that even though the processors are not the controllers, they also have obligations that directly derive from the GDPR, which was not the case before, very little. Precisely in order to, tame the power of those actors. And as part of this, you also have a very heavy regulation of the relationship between the controller and the processor. So let's call it a regulated contract. They don't have to have a contract, but they have to have those stipulations between themselves, no matter how you call it in national law, let's say, that are some sort of in direct relation of what the data processor and the controller should do. As you said, the problem is that they oftentimes the users, so the controllers supposedly, are very weaker. They have weaker negotiation power compared to the cloud processing providers. And it's a case that you see oftentimes. You've seen also this with the relationship, for instance, between Facebook and Wirtschaftsakademie was exactly about this. I would say that in the case of Fashion ID, the court didn't really mind about the power symmetries. With data controller and data processor, I think the GDPR does take that into account through precisely this notion that should the processor end up having their own purpose, then they become a controller. But I think that it's still not that clear cut, especially when they don't decide on the purpose, but they decide upon, let's say, probably all of the means.
It does get increasingly tricky. I think sort of the bizarrest version of that I've seen as a consequence of that case law is basically a regulator being worried that as a legislator, it's not just a regulator, but as a legislator, legislative bodies assume joint controllership if they write legislation requiring certain personal data to be processed, from the perspective that the legislator then also jointly determines the purposes, which is theoretically not that ridiculous if you look at it, but that's very far-reaching. If you say as a legislator, you become co-responsible for any data processing activities that you regulate, then that gets very, very, very tricky. There's a bunch of questions left, but I think we're nearing the end of the session, so I just want to see in terms of closing statements. to see, you know, what sort of your main takeaways would be, and what sort of your main what your main recommendations and or main wish list for the future would be. So I think, Karen, for you, I think question might be, like, suppose that you were have to decide the appeal for the SRB case. What direction would you steer that into? If I make you the Court of Justice for a moment, I think that would be an interesting question for you. And then Charlotte, maybe also you have some time to reflect on that as well, well, a couple of seconds at the very least. Is does sort of the future evolution of the controller, the distinction between controllers and processors, how do you see that evolving over the years? Because it seems like there's an increasing tendency, at least for decisions, to push towards joint controllership. And yeah, you've pointed it out in your slides as well. It's sort of hollowing out that distinction a little bit. So what is the logical conclusion of that? I'd be interested in hearing your opinions to that. But maybe I'll first give the floor to Karen as head of the Court of Justice, the president. How would you decide the SRB appeals?
It's quite a promotion I made there. Thank you.
Congratulations.
Thank you. Cheers. So that's just giving myself extra thinking time. I would tend to agree with the current decision that is there of the General Court, because I do believe if we take it too far and we have to look at illegal means to re-identify people, and we really have to take it that far, it's going to become very hard to work with data in practice and to actually do something with it. And we're not just processing personal data for shits and giggles. We're doing that because we want to advance scientifically, for example. And if you're going to take it so far, it's going to higher the thresholds so much that in practice we're not going to be able to do things anymore. And just looking at the very real risk here, and I think that's important. If there's no risk for the data subjects, then I don't see why we would have to go that far. So I hope the General Court, wins this.
Well, it keeps that balance as well, and says, okay, there is a reason why there is some flexibility there, because the risk assessment is different, and that should reflect also the qualification of personal data or not. Yes. I think that would be a great ruling. Charlotte, from your side, what do you think? Controllership, joint controllership, processorship, do we need to revise that, or do you think we're going in the right direction still?
I will solve all those problems in 20 seconds.
That would be nice.
I think, as you understood, I really plead for purpose to play its role, and I think it does not play its role enough. So this story in controllership is only part of that bigger story. I think the demise of purpose, especially in the case law. Purpose is not an easy thing to deal with. It's not perfect in the GDPR, also because, well, what is a legitimate purpose? Is just making money a legitimate purpose? I mean, there are questions. But I think we used to have a rather good understanding of what a purpose should be, a narrow enough notion so that you can then determine the scope of personal data processing and personal data that are at stake. You know, you have to have a bucket. You have to have a bucket with one person or several persons being responsible for this bucket, and then to tailor those obligations. And I think this traditional view is still relevant. And I think the networked life that we have does not require that we change that. It's quite the other way around. And I think it goes along with probably a blurring of what is and what should be. So probably there are a lot of things that are illegal, but it doesn't mean we should adapt our approach to them. We should start with, you know, being a good lawyer, being a step-by-step approach. What is the purpose? Who deals with them? Who's a controller? Then how to tailor the obligations, and then what doesn't fit in is illegal. So I'm a bit traditional on this.
Bit traditional. So you're in favor till the concepts work, but we have to find a good common sense and rational way of applying them, essentially. Excellent. At least the case law on that point that has not been that disruptive that we need to fundamentally rethink things. I think indeed it's time to wrap up. We're slightly over time, so I want to thank both of our excellent speakers, and thank you also for the great presentations. They will be shared with everyone. Thank you also for the audience. Apologies again for the audio issues. I hope that the transcripts also work a little bit. The recordings will be published. Hopefully there we won't have the same degree of audio issues. If you have further feedback and further suggestions, please feel free to provide it. I'm guessing a lot of the feedback will be about audio, but I hope, notwithstanding that particular issue, I hope the content of the presentations was not lost. I think a lot of very interesting and very good points were made. Thank you very much for being here, for participating. Thank you to both of the speakers for their excellent insights and presentations. And we look forward to talking to you again in future sessions. Have a great day, everyone, and have a great weekend already. Thank you very much.
Thank you very much.
Thank you very much.
Thank
Bye-bye.
you. Bye-bye.